This is Boomer Time, a proactive podcast for baby boomers, about baby boomers, and for people taking care of baby boomers. If that sounds like you, then you're in the right place. I'm Nancy Kogar, an elder law attorney and aging advocate, and this podcast was made just for you. Remember, though, the things we discuss here are not intended to be legal advice, and no attorney-client relationship is established by this podcast. Hello to you, and welcome to Boomer Time. I'm your host, Nancy Kogar. This is a community where we talk about all kinds of issues that impact us as we age. And I've seen that deer in the headlight look far too many times, from adult children who find themselves in the unexpected role of caregiver of an aging parent. You know, that can be incredibly stressful, especially if your family and or your parents have done nothing to prepare for their older years. Well, Boomer Time is all about helping all of us learn more about the legal and quality of life issues that come with aging. What you learn now will and can help you later. Here we talk about everything from estate planning to funeral planning to planning for nursing home care to avoiding it altogether, and planning that can keep you at home in your senior years. Take it from me, if it involves families and aging, you can bet we're going to talk about it here on Boomer Time. Well, today we are talking about a member of the family that is often forgotten in estate planning. That being said, they are an important part of the family. In fact, 95% of us consider them family members. We are talking about your pets, cats and dogs. They show us so much unconditional love. They help us to avoid loneliness, and they need us to make sure they're fed, walked, and cared for, right? So, why do so many of us fail to include them in our estate planning, i.e. our will or other final documents? Dogs and cats under the law are considered property, so they are part of your estate. And if you want to direct who will care for them when you're gone, and or how their care will be paid for, then you have to take those steps in your estate planning. Now, does that sound strange? Yeah, I can tell you, I've seen more and more of my clients asking about provisions for their pets. It's not so uncommon, believe it or not. Now, all 50 states, including Tennessee and Washington, D.C., have enacted very specific laws that allow you to include your pets in your estate plan, albeit with some very specific guidelines. So that's what we're going to talk about today. And it doesn't have to be weird, but I'll tell you, some people take it to the nth degree where it's just downright strange. So we're going to talk about that. Of course, there is always weirdness when it comes especially to Hollywood and the super rich. And they include some outlandish estate planning for their pets. Here's just a few examples. Remember the Queen of Mean, Leona Helmsley? She was that growling billionaire with the hotel empire. Her entire estate was worth about $12 billion. And she didn't just have issues with her hotel employees. Apparently, she also had issues with her family members. So much so that she tried to disinherit them all and attempted to leave her millions to her little Maltese pup, appropriately named Trouble. Well, it caused a lot of trouble when she died in 2007 and led to a lawsuit in which the judge reduced Trouble's inheritance to a cool $2 million. That's still not too bad, huh? After naming her dog beneficiary in her will, Trouble, her Maltese, actually had some death threats against her. And she still requires security that they budget $100,000 a year for. Kind of weird, huh? Well, even the king of pop, Michael Jackson, left millions to one of his beloved pets. Do you remember chimpanzee Bubbles? Well, Michael left Bubbles an estimated $2 million. And today, Bubbles is living out his life in an exclusive animal sanctuary. That's one lucky chimpanzee. And a German countess, she left her German shepherd $65 million. That represented her entire estate. Not only that, it got more complex because her dog predeceased her. However, the dog had left a puppy behind, so guess what? The young surviving shepherd pup took the fortune. Crazy. Of course, we're talking about animals. And animals generally cannot receive an inheritance directly because they're property. That makes sense, right? They don't have bank accounts. But, these examples show you that you can provide for them in your estate plan, and it doesn't have to be to excess. For most of us, it's much more practical and conservative, and it involves some very specific guidelines. So we're going to talk about those today, and when providing for your pets in your estate plan continues after the break, we'll get specific about that. And I'm reminded of that song, Who Let the Dogs Out, right? Come stick with me and we'll be back in just a minute. Welcome back to the show. This is Nancy Kogar, and you are listening to Boomer Time. Today, we're talking about our furry family members, our wonderful dogs and cats, domesticated animals. And if you're a dog lover or a cat person, good news, you can provide for them in your estate plan, and I can help you with that. So, as we shared before the break, there are some crazy stories about ultra outlandish estate planning of the rich and famous. Most of us don't need that, right? And I typically don't see this kind of funding for our furry loved ones. But I do see an increasing number of clients coming to me to complete estate planning that includes their spouses, children, grandchildren, and their pets. It usually involves setting aside money to pay for their care, food, shelter, vet bills, and even their final disposition of their remains. So, simple answer is you can do it, but like all things in the law, doing it is not as simple as it sounds, and it requires some very specific planning under the law, and you have to do it correctly. So, you can't leave cash to your cat. Your cat doesn't have the ability to accept it. Kitty can't buy catnip or open a bank account after you're gone. They need someone to step in for you to care for them as you would expect or provide in your estate planning. So guess what? All 50 states in the U.S., including Tennessee, now have specific statutory provisions that allow you to leave a disposition to your pet after you pass. These laws, as they do here in Tennessee, require that any such provisions to your pets be made in trust, hence something that's known as a pet trust. And I've done plenty of them. And it doesn't have to sound as complicated as you might think. And I joke around, I know, because some of these things are just downright strange to me. But this really is a serious issue because more than 69% of us now have at least one pet in our household. And did you know that the pet industry accumulates some $66 billion each year? So, with all that in mind, it makes sense to plan for their care in the case of an emergency or, worse, your death, right? And trusts typically apply to domesticated animals, dogs and cats. I've never done one for a hamster or a snake, but I suppose you could. Some of these animals, they live a long time. I had wondered about birds, especially parrots and cockatiels. They can live upwards of 60 years or more, so they're often orphaned by owners. I've never done a pet trust for a parrot, but I think given those circumstances, that would seem to make sense to put something like that in place. And you mentioned something, and then all of a sudden you find it. So I did find that there was a lady in New York, of course, who was a fundraiser, and she passed away. And she created a trust in her estate for all 32 of her cockatiels: Wavy, Port, Blackie, Zippy, Tara, Zara, Sasha, Pigeon, Victory, Allie, Zach, Dart, Cubby, Max, Baby, Ruthie, Pumpkin, Tattoo, Susie, Tracy, Margie, Sammy, Angel, Inky, Sarah, Tunra, Tantala, Ava, Cody, Nikki, Avis, and Dragon. Do you think they all knew their names? And she also included her cat, Kiki, and her dog, Frosty, in there. And she gave all the job of administering to the trust to her stepson, who she entitled to use his judgment and discretion as to how to handle the money for the pets. I will mention that her sister contested the arrangement. So I think it is important to note also that, there are different rules for farm animals and more complex animals like racehorses, like the Tennessee walking horses we see up in Shelbyville. But, all these animals are still property and would need to be included in some kind of legacy planning. Of course, horses can be worth a great deal of money. So when you're looking at these, typically pet estate planning includes the following provisions for after you're gone. 1, instructions for your pet's care when you're gone. 2, the appointment of a caretaker or caretakers. And 3, allocation of funds for food, vet services, and don't forget the recreation. I think, generally dogs are not, or cats are not really worth a great deal financially, but they are worth their weight in gold in our emotional attachment, aren't they? I know they are for me. So it's no wonder that Tennessee's legislature enacted the estate planning for domesticated animals, which is codified within Tennessee's Uniform Trust Code at 3515-408. And as I've said, it includes some very specific requirements. In order for you to do it, you got to follow the rules. So there are 2 options for you. 1, you can do it by trust, pet trust. I mentioned that already, which provides for a separate legal entity for the money to go into towards caring for your pets. And that trust also requires the appointment of a trustee, who is a fiduciary and can take on the role of managing the assets and making dispositions and providing for the care that you may specifically provide for within your trust agreement. If you don't want to create a separate trust, you can also make such planning within your last will and testament. If you do that, it's known as a testamentary trust. And that means that you're including provisions for a trust to be created upon your death with the instructions for the care of the pet that survived you. Then your executor at the time would appoint the trustee for the testamentary trust, and it would be managed moving forward rather than being created separately by a trust agreement. So it's a little complex, isn't it? There's some other complications to this law as well. Both of these trusts, whether it's an outright trust or a testamentary trust, must be created to provide for the care of that specific animal. That animal must be alive during the creator's lifetime, and the trust must either terminate upon the death of the animal, or if the trust is created for more than one animal that's alive during the creator or trustor's lifetime, then it would terminate upon the death of the last surviving animal. Got all that? So, and there's one other note. With pet trusts, they cannot be active for more than 90 years. All right, I don't see that being an issue when it involves dogs and cats, but maybe with cockatiels? I don't know. I've never known a cockatiel to live for 90 years, but who knows? Probably out there. If you know something like that, let me know. Well, and the pet trust, whether it's a separate trust or contained within your will, must be enforced by a trustee, a trust advisor, or a trust protector. Or, guess what? Someone else that would be appointed by the court. and someone having an interest in the welfare of such an animal can ask to be appointed. So finally, the pet trust can only apply for its intended purposes. What do I mean by that? Well, if you've provided $5,000 for Fido's care after you pass and say Fido is no longer living when you die, your trustee cannot take those monies and apply them for some other purpose, i.e., give them to an animal shelter in honor of Fido. That's a no unless you specifically provide for that disposition in your document. It's going to be tricky stuff. Trusts don't usually end up in court, but a pet trust could be subject to court intervention, especially if there's some inordinate amount of money directed towards it. In the case with the Queen of Mean, Leona Helmsley, and her $12 million, the court did reduce that amount in the pet trust to what it considered reasonable. Now, $2 million, is that reasonable for a Maltese? I don't know. I wasn't in that case, but it would have been interesting to sit in there. And if the dog or cat does not exist, usually the monies will go towards the creator's successors in interest, who are either the heirs at law or the devisees under the will. So it's just really crazy. Well, are you still with me on this one? Believe it or not, this is serious stuff. And if it's not done correctly, this is why I wanted to mention this to you. It can lead to a dispute in court or just full blown out litigation. And that is definitely not what you want when it comes to your estate. So we're going to take another quick break. And when we come back, I'm going to talk a little about some recent lawsuits that were all done in the name of puppy love. And welcome back to Boomer Time. Today we are talking about estate planning for your pets. I said puppy love before the break, and I gotta share that I used to be so in love with Donny Osmond when he'd wear those purple socks. Oh, silly stuff. Anyway, so we're talking about pet trusts. You can have a trust that's established on its own or a testamentary trust, one that's built into your last will and testament, that's meant to care for your dog or cat when you pass. And, this involves people, so, there's got to be disputes over this stuff, and there sure has been. I did some research on that before the show, and I'd like to share a couple things with you, and I think some of them are just as crazy as some of the outlandish estate planning that we shared earlier. So here's one example. Again, was a woman in New York. So she left $100,000 in a pet trust to care for her kitty cat, Kissy Meow. So the woman didn't have any children, and obviously she loved Kissy Meow, but her nephews didn't, and they wouldn't have anything to do with the disposition to the kitty. So they challenged the trust in court, claiming that their aunt had been unduly influenced by her friend and caregiver in giving money to Kissy Meow. Undue influence is a cause of action that can be brought right here in Tennessee in an effort to challenge a will and even try to set it aside. And the theory behind the claim is that the person who made the disposition was somehow manipulated by somebody else while they were vulnerable or particularly dependent on that person. So, and most of the time we see that with someone that's quite elderly or ill. And, defrauding someone who's elderly, well, that's just plain stealing, right? It's just another form of elder abuse. But back in this case with Kissy Meow, the court didn't find it that way. Actually, after a long and expensive trial, the court ruled that all the evidence indicated that Auntie had been very intelligent, private, and strong willed, and was quite clear about how she wanted to leave her money, even if it was to kissing me out. Sorry, little nephews. Well, here's another example. You remember the fashion designer Karl Lagerfeld? Well, he died in 2019 and he left $1.5 million in his estate towards the care of his cat, Choupette. Believe it or not, the cat appeared, I can't believe this, but the cat appeared in court during COVID by Zoom. I'd like to see that, people. I mean, did they swear the cat in? I don't know what the world why, but it involves people, right? The end game in the Lagerfeld trial was that Choupette came into the care of Lagerfeld's former housekeeper. And so after the trial, apparently, Choupette became a social media influencer with over 250,000 followers on Instagram and making $3 million in 1 year. I don't know. Believe it or not, right? You can't make stuff like this up. That's what I say. I say that about my own cases sometimes. You just can't make stuff like this up. So here's another one out of New York, of course. This one involves Winnie Pooh. Not Winnie the Pooh, but Winnie Pooh, who is a lovable, or so they said, lovable 7-year-old dachshund who was left a $100,000 trust from her late owner. Well, there was a lawsuit filed in Manhattan Surrogate Court to intervene, and it was filed by Winnie Pooh's caregiver, who said that she didn't get the money that was promised and needed for Winnie's care, which was very specific and expensive. So in order to prove their case, the caregiver's attorneys used the ASPCA guidelines to argue that Winnie, the dachshund, requires $6,000 a year for routine care that include dog walkers, feeding, and, the occasional medical procedures. And she said that the caregiver said that she had to pay out of pocket another $5,775 for emergency orthopedic surgery for the dog. So she was asking for that in damages. They calculated that lifetime care for Winnie would be about $90,000 because the dog would live likely for 15 years. Well, with that one, they settled out of court. You know how much they got? $94,000 to take care of the dachshund. Well, you may find all this a little bit strange, or a lot of it strange, but there's no denying that pets are important to people. And if you can take steps, simple steps to secure their care in the event of your death, then I don't think that's such a bad idea. I was looking at how many animals are turned over to shelters, and the numbers are really kind of staggering. So if there isn't anybody to take care of your animals and something happens to you, that's most likely what's going to happen to them, right? And I wouldn't want that. I wouldn't want that for my animals or for yours. So, they say every year there's 6.5 million dogs and cats that are abandoned or lost and just enter shelters in the U.S. And out of that, there's only 3.2 that are adopted, and then they're turned back in a lot of times after they're adopted. So, and you know what happens, they're often euthanized if they can't find a home for them. So, that's not the way you want to have it for your precious pets. And I don't want it that way either. So I think it's important to at least include this as part of the discussion. So that's why we did this today. And, you might be surprised at the number of people that are really considering their pets in their estate planning. And pets are important, of course. And so, as you know, I like to finish every podcast with thoughts of inspiration and encouragement. And it really is true that, a pet can really make such a difference in your life. And they are so willing to just love you unconditionally and can help with loneliness. A lot of older people experience loneliness. So I just wanted to encourage you, if you've got a pet today and, maybe you're not in the greatest health, maybe your pet helps you. Why don't we think about, some additional kind of planning for your pet if something happens? You can even do a POA, a power of attorney for your pet. I love my job. But I'm just going to say a little prayer for all those pets out there. And thank you, Lord, for bringing those precious little pets into our lives. And they're just so loving. They just always seem to be glad to see us and happy and help us to feel loved on those hard days. So I just thank you for them, and just bless all the people out there listening today. And just thank you for including them in this community. Amen. So I hope you have a great rest of your week. And, remember to check out my website, nancykogar.com, because I always have lots of resources there. And you can also contact me if you'd like. Ask me a question. You want me to help you with a pet trust? Give me a ring. If you like the podcast, do us a favor and like it. Follow us on Apple Podcasts, Spotify, and we're going to be on YouTube soon. So better yet, maybe share it with a friend and help get more people on board so they can better plan for their older years. Well, this has been a fun one. Anytime it involves people, it's going to be interesting. So this was interesting. But I appreciate you listening, and I look forward to sharing in more discussions with you that are helpful and, entertaining. So this is Nancy Kogar, and I will see you next time.